Good afternoon. I am Sarah Dunley, Sales Director for Cordium EMEA. I'd like to welcome you all this afternoon to our webinar on corporate crime of preventing the facilitation of tax evasion. Quite a mouthful. I'd like to introduce our Head of Private Client Tax, Anne Healy-McAdam, who's going to run you through the slides. This is a reasonably short presentation, and then we'll be looking to take questions later. You'll shortly see a slide outlining how you can submit questions. As an audience, you're all on mute, but there are ways of posting questions, and we'll try to get to all of them at the end. If it's a little too public for you and you'd like to talk to Anne and follow up from this, please feel free to contact myself and we'll set up an appointment for you to have a chat with her. I hope you find this useful and informative.
Thank you very much, Sarah. While I'm just going to start talking and telling you what all the fuss is about. So, the Criminal Finances Act 2017 introduces two new corporate crimes of failure to prevent the facilitation of tax evasion, which, as Sarah says, is quite a mouthful, so I've nicknamed it FOTI. The new Act will require firms to review their day-to-day business and to undertake new policies and procedures. It's not a paper exercise. Compliance is essential and the legislation will be in force in September. Essentially, this legislation means that the law holds businesses to account by focusing the failure to prevent the crimes of those who act for them rather than those of the corporate itself. It's not holding corporates to account for their customers, merely the actions of their associated persons, which I shall explain in a moment. To give an indication of how wide this legislation extends, tax evasion under common law is any fraudulent activity that intends to divert funds from the public revenue. Obviously, other offences have been created under various tax statutes. For example, Section 106 TMA 1970 provides that income tax evasion is being knowingly concerned with the fraudulent evasion of income tax by that or any other person. As the scope is very wide, it may be advisable to take legislation into account when considering any tax planning and to proceed with caution under this new Act. So, who does it apply to? The offences both include UK and in some instances foreign tax evasion, and they apply to corporates wherever they are incorporated, old-style partnerships under the 1890 Act and limited liability partnerships. They do not apply to individuals. This is a corporate offence. The offence to commit the UK crime of facilitation to prevent FOTI, there must be both a primary tax evasion offence by a taxpayer, followed by a facilitation offence by an associated person, which for these purposes is an employee, agent, or any other person who performs services for the business whilst acting as such an employee or agent. A UK tax evasion facilitation offence is being knowingly concerned in or taking steps with a view to the fraudulent evasion of tax by another person or assisting that person with its commission. Any business is liable if it failed to prevent its associated persons, i.e. those employees and agents, facilitating any tax evasion for someone else. This new offence is a strict liability offence. There is no need to prove any intention by the corporate, and there does not have to be an actual conviction for tax evasion for the offence to apply. HMRC only need a suspicion of tax evasion to commence an investigation, which they can then expand if any information is uncovered. So you should bear in mind that HMRC now exchange and receive information from various international sources about financial and other assets that are held cross-border. So we can expect this legislation to be rigorously pursued. So I'm going to give you an example. This This is a very simple example. John ran a UK business and hid his profits in a bank in the Isle of Man. The Isle of Man Bank has a distribution agreement with a UK LLP for its Cayman fund. John decides to invest in the fund as he does not want to pay any tax on the money, and the Isle of Man Bank requests marketing and subscription advice and documents from the London-based UK LLP. A UK employee of that LLP, knowing that John is evading tax, advises John on how to invest in this fund. So, on a very simplistic level, UK LLP will be liable under this legislation as their associated person, being the Isle of Man Bank as an agent, has facilitated tax evasion. And an even simpler one I'm calling party time. A UK LLP has had a cocktail party for its clients. They bring in outside caterers who provide food, drink and waiting staff. At the end of the evening, the caterer asks the office manager to be paid in cash so that he doesn't have to bother with pay-as-you-earn, and he tells the manager that he always pays the waiters in cash. If that office manager pays the caterer in cash, knowing that they are helping their waiters to evade tax, the UK LLP is caught by this crime. Now to look at the foreign crime. The foreign offence mirrors that of the UK and requires there being a primary foreign tax evasion offence followed by a facilitation offence by an associated person. In order for this to apply in the UK, there must be a sufficient UK nexus, which for these purposes means that the corporate is incorporated in the UK, has a place of business or permanent establishment in the UK, or has a person located in the UK at the time of the criminal act. There must also be dual criminality. That is, the act must be a crime in both jurisdictions, the UK and abroad, and specifically in the UK it must be a deliberate or dishonest act. This is not an offence you can just fall into. There must be an intent by the facilitator to help someone evade that tax. It should be noted that as branches are treated as the same legal entity of corporates for this crime, this may lead to unexpected liabilities. So I'll give you another example. Z Bank is incorporated in Switzerland where it has its headquarters. It has branches in the UK and Germany, and the branches are not subsidiaries, so they are the same legal entity for this crime. Larry has committed a tax offence in Germany under section 370 of the German Fiscal Code. Basically, he's failed to provide complete information to the tax authorities, and he has been assisted in this failure by a bank employee in Germany. So the question is Z Bank liable? If we look at this, Z Bank is within the scope of the legislation because it's got a UK branch. The fact that the evasion occurred in Germany is irrelevant. The UK would consider dual criminality to exist, and Z Bank is a legal person with a business presence in the UK, so it is bound by the legislation. Thus, Z Bank has failed to prevent FOTI. We'll look at another example, the USA Group. Brad is a director of a US parent company with subsidiaries in the UK and Luxembourg. Brad also sits on the board of the UK subsidiary. John is a director of the same UK subsidiary and has a meeting in London with Brad to discuss a potential new big investor, Mr. X. The new investor is an old friend of both Brad and John, and it is known that although the funds he wishes to invest will pass any AML, they both know that Mr. X did not pay tax on this cash in the US when he sold his company. John, after the meeting, sends Mr. X market material and subscription documents for their fund. Again, who is liable? So if we look at Brad, although he is on the board of the UK subsidiary, this may not be enough itself to show UK nexus for the foreign tax evasion offence. However, as he was in the UK at the time when the offence took place, this may be sufficient to fall within the 40 offence. John is caught because he's a UK resident employee facilitating foreign tax evasion. So to lead on the questioning, how does this affect my business? All financial transactions should be scrutinised to ensure there is no faulty by employees or other agents of the business. A prosecution must satisfy a public interest test, but it is expected that those in the financial services sector or multinational organisations will be under greater scrutiny. The sanctions for this conviction: it's expected that the Financial Conduct Authority will want a Principle 11 disclosure, and it is likely that there will be a serious consequence for a regulated body, especially if they are shown not to be compliant with the fraud prevention requirements in SYSC 6.1.1. Obviously, there will be serious reputational damage to your firm if there is a conviction. On conviction, there are unlimited fines for the business, and business assets may be confiscated. Note, it is business fines, not personal. So if it is a partnership, it is the partnership assets, not of one individual partner. HMRC have very broad powers of investigation with regard to this offence, and it is likely that there will be an increase in DON raids to firms where there is a suspicion of faulty by an associated person. A serious crime prevention order is also available, which requires individuals to provide information and answer questions from HMRC. Failure to answer any of these questions without reasonable excuse is a criminal offence itself. Thus, it is likely that senior staff will be questioned under such orders to identify faulty within their firm. As stated earlier, this is a strict liability offence. However, the good news is that there is a statutory defence available. The defence is that reasonable prevention procedures have been put in place and that you can show that these are adhered to within the firm, and that a culture of non-acceptance of such behaviour is embedded within your firm. So, what to do next? Simply set up procedures. HMRC have issued guidelines to assist firms in demonstrating that they have established reasonable prevention measures. They have identified 6 guiding principles. The first step is that a risk assessment should be undertaken to ascertain who in your business has the means, motive and opportunity to facilitate tax evasion. Review all of your associated persons to include employees, agents and those who perform services and who act as agents, and segregate such individuals into low, medium and high risk, as obviously those in lower risk groups will not require the same amount of training and oversight as the higher risk. Any procedures undertaken should be proportionate to the risk of your business, employees and agents, and obviously the size of your business. There must be top-level commitment, so senior management are expected to take responsibility for the implementation of prevention measures. This could be engaging with associated persons to certify risk, or implementing bespoke HR procedures. They must be seen to be acting. Due diligence procedures should identify the risk of faulty by associated persons, whether by their role or geographical location, as for example those resident in countries which do not subscribe to the Common Reporting Standard are likely to be more risky. Communication and training. Procedures and policies should be embedded within the business. There should be a whistleblowing policy and staff should be informed of their legal duties as an employee and the possible consequences of a conviction to the business and their personal livelihood. Training should be available to those who are more at risk to ensure that they understand the crime and should be monitored as part of their annual review. As your business and risk evolves over time, together with the HMRC's response and the use of these new offences, so your procedures should develop. It is recommended that your marketing and legal team review their material and contracts to ensure that compliance is achieved and that the firm itself continues to monitor and review its own policies. So the good news is that Cordium will be able to assist you in complying with these new rules, and in particular in establishing procedures which should satisfy the requirements of the defence. Can I emphasise that this is not a paper exercise, as with the consequences of non-compliance could mean your whole business. So I would recommend that you start reviewing as soon as possible. Thank you very much, and I hope that that's given you a short insight into this new legislation.
Thank you very much for that, Anne. Right, well, either you covered the topic so sufficiently that nobody has questions, or potentially we have an audience that is a little scared now. If anybody would like to post a question, we've had one talking again about the individual nature of this. A question for you, Anne, would the HMRC prosecute an individual?
No, this is a corporate crime, so it will not affect an individual. So if you have an individual partner in a limited liability partnership, or any partnership indeed, if that partner was evading their own tax, that is their own crime. It's got nothing whatsoever to do with this. This is a corporate crime where a corporate or partnership is basically making sure that their employees don't help someone else evade tax.
Okay, so the next question is, can you comment a bit more on associated persons and how this offense may apply to a fund's portfolio company? For example, does a portfolio company offense count as an offense by the fund manager?
No, it wouldn't. An associated person basically is your employees or your agents, or someone who is holding themselves out to be an employee or agent. So unless you actually had an employee who was a member of your LLP and also on the board of the fund, you would not be looking at what the fund was doing. It's only your own employees that you're looking after.
Excellent. And we have another question that came through. How do you apply to a fund's portfolio companies? So I guess how would you apply this rule to a private fund's portfolio companies?
Again, you are looking at the board of the companies. If you have employees in those boards or agents in those boards, it's only then that you would be liable. If the fund is quite independent and separate from you, you will not be affected. You're only looking after your own housekeeping.
Great. And we had another question that came in. You mentioned reviewing contracts to ensure compliance. What kind of wording should be included? Are we talking about adding representations in the agreement that the agents or counterparties are aware of the legislation?
That's exactly what you're talking about. I would recommend that you speak to your legal team and that you ensure that whoever it is you are acting with or contracting to, that they are compliant with this new legislation.
Excellent. And it looks like that's all the questions that we have for today. So thank you, Anne, for this webinar. It's been very helpful. And thank you all for your questions. We appreciate it. And we will, if you have any more questions, again, feel free to reach out to Sarah, and she will be able to set up a meeting for you with Anne if you have additional questions. Thank you very much and have a great day.
Thank you.